You're listening to Artful Divorce, a podcast dedicated to helping you make sense of the divorce process. I'm John Kinney, a family law attorney, and I'm here to help you find clarity with practical advice and compassionate insights. Hi, this is John Kinney. We're here with the Artful Divorce podcast for part 2 of our parenting plan podcast with Kelly Gering. Before we get started, I'd like to clear up the record. I think last time we were here, I said that you were a therapist, and I was wrong. I think you office with a number of therapists?
Yes,
okay.
I do. Mm-hmm.
So I was a little confused. So while we're on that topic, maybe just describe your career a little bit in terms of what made you decide to go in the direction of, I'm going to be a mediator. This is what I'm going to do with my life. And this is the direction I'm headed, and not really, like a lot of mediators have a therapy practice. How did that all come about?
Yes. So in college, I was a philosophy major and thought I would go on to law school. I studied abroad and on a mountain somewhere in Greece decided I'm not supposed to be an attorney, came down, this is in the 90s, and I faxed my dad. And he said, well, then why in the hell did you get a philosophy degree? At that time, alternative dispute resolution programs were starting. And so there was more conversation about mediation as an alternative to litigation, particularly in the world of family law. So I then went on to graduate school, and I got a graduate degree in conflict resolution. And I came back to Nebraska and I started practicing for a little bit, and then I had a family, and then I started teaching at Creighton, and I still teach there now in their graduate program in negotiation and conflict resolution, and then went fully into private practice about 8 years ago. But the reason I am an adult child of divorce, and I knew that I wanted to be able to help people have these difficult conversations and to be able to be a bridge for people to learn how they could do it as constructively as possible to minimize damage and conflict to kids. And so that was always my why. And I had kind of a circuitous path of getting there, but I feel like I made the right choice, and I enjoy the partnerships with attorneys, and I enjoy the partnerships with therapists. And I think that it's an entire circle of support for people going through a really difficult time. So a little bit of me.
You have talked in other podcasts about the team approach, whether it's formalized or informal. It feels like the best divorce outcome oftentimes is, oftentimes it brings in other professionals. Mm-hmm. And the collaborative approach obviously brings in other professionals, and that's a formal approach to creating a team. But I find that even when you hire a litigator or you do a traditional divorce, that if you have your own therapist, or the children or a child has a therapist, and you have professional resources. So, for example, an informal thing would be having a brother who's an accountant.
Sure.
And so you bounce things off of a professional that has sort of some skills in an area that's helpful to your divorce. I think that happens all the time. And then I think when you have a mediator involved in creating a parenting plan, and you have your own therapist, and you have a professional that can help you with money issues, that's just a great way to sort of navigate a divorce. And so it's something to think about. That's not really necessarily part of what we would talk about here, but I did want to transition and sort of talk about some of the more nuanced issues in parenting plans that we didn't get to talk about the last time you were here. Just to recap, my recollection of the last time you were here, part 1, was that we sort of talked about schedules. We talked about the mediation process. We talked about a lot about how people should approach mediation and how people handle mediation, our experiences. And we talked, I think, about legal custody issues and holidays and summer and exchanges. I think we spent a fair amount of time talking about exchanges. So I wanted to talk about some other things. I don't think we had a chance to talk a lot about parental communication. And that is a huge issue in my practice. And so it oftentimes comes up that in-person communication and telephone communication devolves into conflict. And so how do you approach parental communication when it comes to higher conflict cases where people do have a difficult time communicating?
I would say that co-parent communication is one of the primary challenges as people are moving through the divorce process, and then as they are divorced and are trying to navigate what it means to be co-parents in two different homes together. And interestingly, I find that one parent will usually say, well, we should be able to talk to each other. We should be able to be flexible with each other. We should be able to use this parenting plan as a guide and then kind of work with it as life emerges. And then the other parent will say, oh, I can't talk to her. I'll say one thing and think that we're doing this, and then she'll twist it. And so I really need to have more structure and guidelines. And in fact, I'd kind of like to minimize communication. I'd like to just talk about the important things with the kids and not any extraneous things. So I will frequently encourage parents to at least start with, and maybe they don't use it for forever, but I think that a co-parenting app can really help them to, on many levels. A co-parenting app can help to organize them. So it has a shared calendar with color-coded parenting time for each parent. They can upload their holiday definitions. It has a portal for all of the providers that touch the kids, so pediatrician, eye doctor, dentist, coaches, teachers. But then it also has a messaging function that timestamps dates and is uneditable. And text messages, emails are all admissible in a court of law, but text messages can be edited and frequently should just be used for day-to-day things like he left his backpack in my car, she got a fever, or something like that. But the more in-depth conversations, a co-parenting app will ensure that it has a dedicated thread, that both parents are getting the same information. It archives all of the information. So by keyword, you can go in and search and find every conversation you ever had about braces or changing schools. And for at least the beginning, it gives a space where documentation can happen for both parents. And I don't know why this is, because we cannot see the information unless they show it to us. But I think that parents behave better when they use co-parenting apps than when it is, and they certainly shouldn't be having this communication at exchanges. But if they pick up the telephone, there's a level of escalation and emotion that can happen faster that way than if they have some time to think through what they're going to type in. And typically in every parenting plan, we will have a co-parent communication/decision-making protocol. And within that, unless it's an emergency, we always state that parents would have a reasonable amount of time to respond. So 24 hours, 48 hours. This gives parents time to pause, reflect, not maybe type in immediately what they, are feeling in the moment, but really kind of think through, okay, here's the request, here's my idea, this is what I think should happen next. So I do, and I think it gives a record for both parents of what they've communicated about, allows them to easily go back and review the conversations that they've had if they need to. And again, they may not need it for forever, but I think that at least in the beginning, when emotions are high and they're doing this for the first time, figuring out how to keep them in as much of I will frequently tell them, you're moving from the relationship of being married to the business of raising great children. So think about being a business partner with this person. What would professional communication look like with a business partner? Then you should be thinking similarly and doing that with your co-parent. Your co-parent has equal responsibility in raising these great kids. So talk to them as if you would want the same level of respect. No personal insults, derogatory comments. bringing up the past, it doesn't help. And it devolves quickly, and we don't get at the need of the child. So I just encourage them to reshift their framing of how they're in relationship with their co-parent, and using an app can help. And there are a million apps out there. There are 3 that kind of come to the surface that I will frequently tell parents, and that's Our Family Wizard, App Close, Talking Parents. But you can get online and find a million of them, and then decide on one and trial it with your co-parent and see if that's helpful.
We went through a lot just then, and you have some really, really good insight, and you ticked off a lot of things that, triggered some thoughts, on various elements of what you just talked about, and it is a big, big issue for parents. One of the thoughts I had as you were speaking about a parenting app was this notion that keeps coming up, and that is that good fences make for good neighbors. And so if you're going to launch into this new, parenting relationship, it's better to build structure and then back off of that structure instead of trying to go forward with less structure and run into problems. Yes. And so, that's my sort of homespun phrase for it is good fences make for good neighbors. But it's just boundaries, just kind of creating ways to stay within boundaries. And as you spoke about some of those things, I oftentimes will talk to clients about, I hear the real bad problems, right? Mm-hmm. And so one of the things that happens is I send a message saying, hey, we need to pick an orthodontist. I went and interviewed this guy. Here's what the bill's going to be. Here's why we need braces. And then total silence, right? That's just an example. But one way to be controlling or to be mean-spirited is to just give the other parent a brick wall on something that's kind of important. And so you were talking about, hey, you need to respond within 48 or 72 hours of a text. And so when you're in mediation and somebody says, well, I just don't have time to get back, or, they text me all these stupid things. So I get like weary of all the communications and they're overwhelming me. So I just don't respond. How do you navigate that with parents when one person is probably over communicating and another person says, well, because you're like that, I'm going to blow you off?
It's an excellent question. It happens a lot. So sometimes we will come to agreements about when these communications can come. So I would say that we will come to agreements that say one message a day, unless it's an emergency. So for example, you're not going to batch or bundle 5 different messages, or you're not going to blow somebody's phone up, and we're not going to do that during work hours. So a lot of times you could send the message on the app at 9:15 in the morning, but don't expect your co-parent to do anything with that during the day or maybe even that evening. But the following day by 9:15 you should expect to see something. And so we've had some guardrails around that, and we can say no more than 1 message a day. Do not expect to be responded to during work hours. If a message does not have a clear action item, so typically within the protocol we'll state, provide the issue that needs to be addressed, the specific question or decision point that needs to be determined, and what you would recommend. So for example, if it's braces and the co-parent says, I did a consultation with our child, it's going to be $5,000. They want to start the treatment September 1st. Would you be in agreement to use this person and pay $2,500 to begin the treatment plan? That's a very clear, direct, you're giving information, you're asking a question, and then maybe the bottom part of that email or the end of that note says, I like this orthodontist for X, Y, or Z reasons, meaning why you would think that would be a good person to use. So I think we limit the number of messages, we limit making sure that it's not happening when someone's trying to work or trying to, do what they need to do. But we also have an expectation for response time. And I have put into parenting plans that if parents do not respond within a week, for example, a parent can move forward with that decision. And sometimes that's a way to navigate it. Sometimes we will have parents refer back to the parenting plan and say on page 5 of the communication protocol, we agreed to respond to one another within, 24 to 48 hours, and I'm waiting for a response. Can you provide me with information? So I think it's what we're searching for is what is reasonable so that one parent isn't being stonewalled and the other parent isn't feeling like I am exhausted by the amount of communication that is coming in, some of which may be about our child, but some of which has nothing to do with our child. And I don't want to have to, a lot of times why they stop doing it is because they assume it's just more about blame or frustration about something. So I would say having a clear structure in the plan about what the note should look like, when it is that you should expect a response, and to an extent, what happens if you don't get a response. And I would say that's probably your world. They ask me a lot about that. And what I say is if you go time after time after time of not getting a response, that's the power of the co-parenting app where you have a lot of documentation to show that you've reached out, that you've abided by the parenting plan, and that you have received no or not meaningful responses back. And in a joint legal custody scenario, that really hamstrings people to be able to move forward with decisions that need to be rendered. So,
So a couple things just to follow up, and I talked about this with a number of people. Communication during exchanges just should never really take place because exchanges are already fraught with high emotion sometimes, and just exchanges are a bad place. But I see it. Hey, you didn't respond to my text. Are you gonna get back to me in front of the kids? Right? Just escalates everything. It's harmful to kids for that kind of thing to happen. So, I don't know if it has to be in a parenting plan, but I'm assuming that you've had parenting plans where, hey, we've had problems with exchanges. Don't talk about any issues related to kids or anything else during exchanges. It creates a little silence, I'm sure, and maybe awkwardness, but you could be cordial. You just don't bring up the divorce issues or anything related to making decisions during exchanges. I see that rule getting sort of broken all the time. It's just hard on kids. And then just to kind of weigh in on some of the lawyer thinking on some of the things that, and it's not really lawyer thinking. I think mediators do this too. I tell my clients, look, if you're going to communicate in writing. Parenting app's great. Text is, second, telephone third, in person fourth. A telephone provision would be if there's an emergency. If you're headed to the emergency room and you don't think it's appropriate to put it in an app because that might not get opened, you make that call, right? But I tell my clients, look, everything that you communicate with your spouse or ex-spouse about has to be related to the children somehow. You can't go through relationship issues or the reasons for the divorce or blame or personal attacks or talking about their family and how bad they suck and all the things that we see all the time in parental communication. It just has to be related to children. And really, I spell it out. Dates, times, and places for pickup, health issues, medical issues, education issues, discipline issues, maybe even sometimes religion or, cultural issues, but it has to relate to your kids. And people break those rules all the time. And then I tell them, when you communicate in writing, it has to be about one of those things. Don't give a laundry list. Here's all the 5 different things that we need to decide. Just make it about a single subject matter. And then I don't know how you feel about this, but I always say just make it 5 sentences or less.
Yes.
When you see the too long didn't read type of communication, it's just sometimes overwhelming. So those are some things that I've learned that might be helpful in communication. I don't know that they have to be spelled out in a parenting plan, but again, it helps, better fences, right? So spell it out. Like, if we're going to communicate, this is how we're going to do it. And I sometimes think that that's helpful for people to understand. I think impulse control is difficult for one or maybe both parents. And so the piece of paper, again, is there,
Yes.
but people blow through that when they get mad.
Well, and I don't know, this is what you see, but many people tell me that they could not communicate well as married people. So then the idea that they're going to become great communicators as co-parents in two separate homes, it's almost like they have to learn that. They have to practice. They have to your point, regulate their nervous systems, which means that they need to have somebody that they can talk to about their feelings. She always, he never, they didn't, this is insane. I can't believe that I'm having to do this. They're never going to change. None of that belongs in co-parent communication. That can be the conversation that you have with your therapist, with your best friend. And honestly, you might be right, but that's not helpful for how it is that you're going to move forward with what you need for your child. And I agree with you, keeping it simple, to the point, and not bombarding one topic per message. And then just making sure that you have an emergency, and that's always, for me, the telephone, as fast as you can get to the other parent.
Yeah. There is some thought about how other states sometimes handle parental communication. And I think I've mentioned this in another podcast, but I learned that in Florida, the judge and the judge's email is listed as a party that can receive the parental communication. And I find that fascinating, because I guarantee you judges aren't reading communication that occurs between parents, but just the idea that there's an email that's sent to the judge about your communication, and that if the judge wanted to, he or she could look up your parental communication. I just find it fascinating and awesome, because I think it would eliminate a lot of problems if people just had this concept of the judge having instant communication or instant access to your parental communication. It would have I think it would really, have a chilling effect on some of the problems that we have. And again, logistically, it would be overwhelming to a judge to try to monitor parental communication. But I just throw that out there as something that I'm sure for you, is this the first time you've heard of something like that?
I have never heard of that. Yeah. But I do, just from my own experience, people behave better with professionals. I mean, they'll tell me all the time, he or she has never talked to me like that, like they're talking right now with you in the room. I wish we could have talked like this a long time ago. Or, I mean, I've had cases where I have been I've been the one that communicates everything between the two of them for months and months and months. What I try to say to them is, this is not sustainable. The goal is for the two of you to be able to do this together. And yes, is it nice to have somebody in the back of your mind saying this could be punitive if I say something terrible? Mm-hmm. Yes, it is. But ideally, what we want is for them to get to a point where even when they feel it, they don't say it. And hopefully over a period of time, the wound dissipates a little bit more, and they have the ability to become better business partners in the communication than they could before. That's the vision of what can be. Doesn't always work out like that, but.
I want to talk about international travel and passports and travel in general. It does come up. And I just had a case just in the last couple of weeks where a parent wants to go to Mexico with the kids. gets stonewalled. John, I'm at my wit's end. I need to get these passports. He or she won't respond. They won't sign the documents necessary for me to get passports. Why can't I travel internationally with my children? How do you approach that? How do you handle all that?
Yeah, it comes up all the time, actually. Yeah. When we are negotiating vacation, typically I'll have a conversation in the intake process and I'll say, do your children currently have passports? Depending upon the ages of the kids, especially if they're young, many times they don't. And so as we know, it requires both biological parents to sign off on the application when a child is under the age of 16 to be able to secure a passport. And frequently what I will hear is, well, I don't want any international travel for my kids until they're X age. And a lot of times what they'll do is say, like if I've got 3 kids and they're 10, 8, and 4, I don't want them to go anywhere internationally until the youngest is 10 or, fill in a blank. And so it's challenging because, I'll say, do you imagine that your co-parent is going to be taking the kids to Gaza? No. Where do you think that they would be taking them to? Like, it's typically a resort or something like that when kids are younger. When kids are older, it could be Europe for 10 days. It could be, but for the most part, they're going to a place where they're landing and they're going to be there for 7 days, 8 days, 9 days, something like that. And so what we try to negotiate is why? What is it about having a child that is older that makes you feel safer about them being able to secure a passport? What do you think is reasonable? And also, what do you think would be good for your child? Like, is this something that would be a great experience for them to be able to have, to see another culture, to hear another language, to have different food experiences? And so we try really hard to figure out how to negotiate when kids can go. And usually it's if parents are like, absolutely, I want that experience for my child, then we negotiate notice time periods. So like if you're giving a 30-day notice for a domestic vacation parenting time, usually an international one is going to be more. So 60-day notice, 90-day notice, something like that. And then the conversation turns into who keeps the passports. Like, is the passport going to always be at dad's house or is it always going to be at mom's house? Sometimes in parenting plans, we'll say that they will alternate years. So 1 year with one parent, 1 year with the next parent. But it comes up a lot of the time. And the barrier of one parent not going in and filling out that application and allowing a child to have that experience, I just really try hard to probe why. Why would you keep your child from having that experience? What is it? What are the safety parameters that you might need to feel better about your child going to Mexico or Costa Rica or something like that, whatever the experience is. And that can help, but it is fraught. It's challenging because usually one parent is a lot more comfortable with their kids going and traveling than the other parent is. Maybe just because they themselves haven't done it before and they're worried about what that would look like to be away from their kids for that length of time. But
yeah, so there's the issue of trust comes up there, and it's just one of those fundamental things that two people trust each other, fall in love, and have children together. And then when the relationship breaks down, there are all sorts of issues that come up where there's a failure of trust and a lack of trust. And so you have both parents or one parent that just doesn't trust the judgment of the other parent after a breakup. And so that usually in this context means I don't trust you to take care of our kids if you're in Mexico. I don't trust you to watch them. And so kind of becomes a little bit of a control issue. And I've had experience with a number of different travel issues, and there are nations that are more terrifying than others, and that have breakdowns in government and in law enforcement. And so the State Department issues security notifications about different places. And sometimes people are from a place, their parents, their extended family are living in an African nation that may not have a super stable government, or it may have a high crime rate, or it may have the potential for civil war or conflict, genocide, all these things. So it's not really as simple as just saying, well, geez, it's, you should be able to travel internationally no matter what. So what ends up happening in my world is these are the countries that I'm comfortable with, right? And then anything other than that would require a written, like a change, like we'd have to agree in writing on it, or you would have the opportunity to go in front of a judge. The more parenting issues that are more minor that you put in front of a judge, the more they roll their eyes. It's like, why am I deciding whether you can go to South Africa or not? I mean, give me a break. Right. You've been divorced for 4 years, figure it out. But I've seen it. Mm-hmm. I've seen it come up, and it's a little bit more complicated than just, So I'm kind of talking all over the place, but I think if you did have one of those situations where somebody was a citizen or a dual citizen of another country, or all their family was from that, you would get into the specifics about traveling to that country and what are the parameters of all that, right?
Oh, absolutely. And we would talk about what are the forms of communication for the non-vacationing parent with the minor children when they are in another country. Like, we still want to have some way to make sure that they've landed safely, to have touch points. And it doesn't have to be a daily touch point, but some ways of seeing, I see my child, I hear my child, they're okay, because it can be scary. And I think that those are really good conversations for parents to have. Like, these are the places that don't feel safe to me right now. I may be open to having this conversation later, but these are the reasons why it doesn't feel safe. And can we have some agreements that maybe the child would need to be older before we would reevaluate that? So again, I think reasonableness, but getting at the heart of what the parent that wants to take them, what are they wanting the child to experience there? And then the concern of the parent that is like, absolutely not. That feels nerve-wracking to me, because as you said, the trust is fractured and they are trying to figure out business arrangements that they can agree to make sure that their child has experiences, but that they're also safe.
I'm going to pivot a little bit. I want to stay on the topic of vacations a little, and I don't know if we talked about this, but traditionally in the early part of my practice, we talked about vacations for kids occurring just in the summer. And then I've noticed a progression particularly with mediators, where they are saying vacation can happen throughout the year. And then I see these provisions that, okay, you can pick these vacation dates during the year, and this is how we do it. And then I get, well, they purposely picked a vacation day in the year when they know that my new spouse and I are having our family reunion or something, where the vacation has somehow become a weapon when you can pick it during the year, and you can pick one day here and another day here. And that feels gamey and awful, and like a recipe for a lot of argument. And I've seen it a fair amount. In your parenting plans, how do you handle, you want to give parents the opportunity. So the biggest thing that comes up is skiing, right? That's not going to happen in the summer, typically in the United States, right? So one parent loves to ski and wants to take the kids skiing, and maybe spring break or Christmas isn't the right time, and they want to pick 2 or 3 vacation dates to go to Colorado. And so how do you handle that, cherry picking behavior that happens with vacation days during the year?
It's a really good question. So I think that when I first started mediating, I would see that as a general template that you would get 2 blocks of 7 days within the summertime to utilize, and that it was only available then, and then you would have your holidays during the course of the school year. But I think as I've pivoted and hearing that commentary, some parents can't take an entire week off of work, for example, in the summertime, and so they want more flexibility to be able to. Maybe they can take a Monday off of work when their child doesn't have school and they can make it a long weekend. And so I will talk to them about the possibility of having almost like a PTO bank of, let's say, 7 days, 10 days, whatever the two of you would agree to. And then we agree to no more than X number of consecutive days. So whether that's 7 days, 5 days. But there's almost always a provision in the plan that indicates that if there is a family wedding, reunion, graduation, special occasion where it makes sense for the child to be there, they're a part of that family, that parents would work with one another to ensure that they're able to do those things. And then as far as the cherry picking and using it as a weapon against the other parent, vacation parenting time, you don't have to take them anywhere to use that time. It can just be considered bonus parenting time within a calendar year. But what I always ask is, think about what your child would want. And for me, the consistency of the schedule, at least in everything that I hear that gets kicked back in remediation, is key for families. So we want to try to keep the schedule as intact as possible. But also at the same time, if you have an opportunity to take a day here or to take a day there, but not to take 2 days out of some parents' week and get an entire week with them and then do it again 2 weeks later, you want to think about what is going to serve your children well. And I think that for the most part, parents like that flexibility because if over winter break they can take 4 days and they can go to Colorado and they can use that opportunity to ski, then that's great. But I do have parents that come back and say, I took these 2 days, and so then she took those 2 days just to get me back for taking the days. And I say to them again and again, where are the children in this? Like, are you taking those days because you can take the time off of work and you can be with them and you can have fun and enjoy them? Or are you doing it because you're looking at a tit for tat situation? And that's not, again, centering the kids around the purpose of the time. So if you want the flexibility, I think the number of consecutive days helps. We almost always put into plans that if there is a conflict over dates, that one parent gets preference in the even years and the other one gets preference in the odd years if they're wanting the same days. Just trying to mitigate conflict. But ideally, if it's possible, I think it's nice for parents to have the option over a calendar year. We don't take kids out of school for that unless by mutual agreement of parents and minimally to do it. But it gives them more options, I think, rather than just having a block in the summertime.
What I see is a parent sometimes, I know I'm giving you horror stories, but I see a parent saying, oh, that day 6 months from now is going to be really special in the life of our child. And I'm going to pick that as a vacation. And I'm going to exclude the other parent from either some or all of participating in that. And it's just awful to talk about it like that. But I do see it happening. And I oftentimes wonder if there isn't a better way, again, better fences, just to try to figure out a way. Okay, you can take vacation during the school year, but how can we manage this in a way that doesn't allow a parent to poke the other one in the eye over that sort of thing? And so I guess it's just something that if people are going to go mediate a parenting plan, I don't think people think about that a lot. And then they find out a year later, oh gosh, this being able to pick a single day or 2 days during the school year is really coming back to bite me. I didn't realize it was going to be so gamey.
Right.
And so I think it's something for people to think about. And I'm sure you have methods of writing up a parenting plan to try to minimize that, but I'm not really sure, how much you can minimize it.
Right. And I also think they know their co-parent too. So if they say to me, oh, that's not going to work because I can absolutely see her grabbing this day just to spite me or taking that, then I will say, okay, then how about we propose that it would be 1 week in the summer, and then that's what we're going to do. And then that just means that you can't do, unless we make spring break a holiday and we alternate it, and you could use that time for something or fall break or something like that. But then you just understand that you're limited, but you feel like there's greater freedom in that because you're not worried about your co-parent coming in and taking time just to spite you in that capacity, because they almost always know. They know what they think will happen. And if they don't, and it does happen, and they're documenting it, then they'll come back in a year or 2 years later and say, we have to really revisit this. It's not working for these reasons.
I mean, I can't tell you how many times over 32 years a parent or an opposing party has said, they won't let me talk to our child during parenting time. And judges have to be tired of hearing about it. And it just keeps coming up over and over and over again. And it's a recipe for conflict. So FaceTiming, telephone, people come in and they're high conflict. How do you handle that?
That also happens all the time, all the time. Okay, let me tell you some of the things that I hear. They'll say, we have an agreement that we can talk once a day, but whenever I call, she never answers. Or, yeah, he lets me do a FaceTime, but he's right there. And he's actually answering questions that I'm asking the kids, so I don't have a private area upon which to communicate with my children. Or he never calls during my parenting time, so it's not a big deal for him, but I do want to have a touch point with my kids when they're with him. So meaning that the priority is not the same in that situation. I almost always hear both parents say, but I don't know whether it actually happens in real life. They'll say, well, I would always allow the kids to call if they ever asked. I would never deny them the ability to talk to their parent if they ever asked. And then what I hear from the other parent is, well, they're telling me that they want to talk to me, but she said that they couldn't, or that we're too busy right now, or that we don't have time. So I ask, again, going back to what is reasonable, is it reasonable to disrupt somebody's dinner time or bedtime routines or getting homework done? Or is it reasonable to ask for somebody to talk multiple times over a parent's weekend? No, in all of those situations. Like, a parent does need to be able to have meaningful time with their children when they have them. Are there agreements that we can come up with that are helpful for kiddos? And especially if they had a test and a parent wanted to check in and see how it went, or just to say, I'm thinking about you. Yes. And a lot of times what I will say is, depending upon the schedule. So if a parent has a 2-2-5-5 and they have a 5-day stretch, maybe we come up with an agreement that says there's not going to be any communication on the 2-day stretch because on the 3rd day you're going to see them. But on the 5-day stretch, we can say once or twice. And maybe that looks like that parent reaching out and saying, the non-custodial parent reaching out and saying, can you tell me a good time that I could give a call? And then that puts the control within the custodial parent's realm to say, okay, we finished homework, dinner, bath, and we're getting ready for bed. Now is an okay time to call. But again, I try to bring it back to what is reasonable. And it's very hard when one parent really, really wants it, and when the other parent is fine to not have it during the other parent's parenting time. But I also say, too, that this is only for a window of time, because then eventually children do have their own cell phones. And then usually parents are able to communicate directly with them in that way, as long as they're doing it during appropriate hours. So it's tough to navigate, but we also have in parenting plans that if they are going to have a FaceTime call, that you should try to respect the child's communication with their other parent and not be hovering over them It's tough when you have little kids, and you got to hold the phone for them, or you got to, manage that process. But I think that we try really hard to put some kind of framework around it that feels child-centered but reasonable. Now, in the event that it doesn't work at all, sometimes we have to say that there is no communication with the minor children during the other parent's parenting time unless the minor child requests it. And that's hard for parents. But if it creates added conflict, and particularly if the child is hearing or seeing that during those calls, and their parents can't figure out how to manage that and just make it a pure experience for the child, then that too is not helpful for children.
Yeah, it sort of bleeds over into the right of first refusal type situation. So the problem with the right of first refusal in some respects is that it's an interruption to somebody's parenting time, right? And, the flip side of a parent who really, really wants to talk to their child and is denied that, and that's unfair, right? The flip side is there are parents who are a bit neurotic about contacting their child every single day. And, maybe neurotic is a label or something, but there are parents who don't understand that their sort of desire to communicate with their child is not healthy necessarily for their child, because it disrupts the flow of that possessory parent's parenting time and puts maybe into the mind of that child the conflict or the other parent being unhappy with something, and may increase anxiety for the child, all because a parent has an issue that is very parent-centered and not child-centered, right? And it can be kind of selfish. Mm-hmm. And so it is sort of complex. Like, the motivations are very different. People's attitudes towards the communication can be very different. And it can disrupt the possessory parent's enjoyment. So I don't know that any of that can be addressed in a parenting plan so concretely that it solves the problem.
I don't think so, because the problem in doing that, and I've had these experiences when parents agree, we will do every other day. A parent can call from 7 to 8 p.m. When it's that rigid, sometimes it works, but other times then I'll get these messages, multiple times I call and they don't answer their phone, and then they'll say, "Oh, I'm sorry, we were busy doing stuff, have a good night," or something like that. And so having it rigid in that way, I think, can create additional conflict. But first of all, I have a lot of empathy for parents who never thought that they were going to have quote unquote half the time, with their kids, when they're used to organically on a daily basis checking in, seeing how they are, hugging them, being connected to them. So I honor that from the get, because I think that that's a really tough thing. And until they have their own cell phone, you are reliant upon the other parent to help facilitate that communication. That said, what I try to tell the parent who is yearning for the communication, and we're trying to negotiate what that can look like, is to say, if you allow your child to have this time away from you with their other parent, think of all of the great conversation that you're going to have when you see them again, and all of the wonderful things they're going to be able to tell you about what's going on at school and X, Y. Like, you're going to get caught up on all of that. And if there's something special, there's a program at school and maybe you're unable to attend that and you want to wish them well the night before, I'm sure that can be something that can be, done. But it's almost reframing the way that you engage with your kids from the way that you did it before. And it's really tough because you used to have full access and now you don't in the same way. And especially when it's really tense with the co-parent, that's just another way that they feel like they're being hurt by them, is not being able to have the kind of frequency of connectedness that they want to have with their child.
Yeah, even the cell phone doesn't solve all the problems, because, I have situations where a child, a preteen or a teenage child, has a much more affiliation with one parent. And then they go to the other parent's house and they spend an hour and a half at night texting with the parent that is more connected with them, or you can use bonded or attached, or,
Sure.
and the parent who's trying to develop deeper bonds, and trying to make that parenting time meaningful, struggles. And that, that's another problem. I don't know how you solve that. But what I see parents do is say, I'm taking your phone, because if you're going to text your mom for 2 hours,
Right.
and sit in your room and not come to dinner with us, or not interact with your, your, I don't know, your family, then, and then of course, taking a cell phone away from a teenager is a nightmare. Right?
Yeah.
So, I don't know. It just seems like a conundrum surrounded by a problem wrapped in an enigma. And I don't know how you solve any of that.
Well, and then you have with cell phones, which parent got the cell phone, which parent paid for the cell phone, what the rules are at each parent's house. Sometimes kids can't have their cell phone at the other parent's house. So it becomes just this quagmire of craziness. But what I do say is, I understand that you want to talk with them. I understand that you miss them. I understand that you wish that you could every day have a touch point with them. In the event that your co-parent is, unwilling or unable, let's start thinking about how great that it's going to be when you do have parenting time with them. And if it's a long stretch of time that you have to go, sometimes we can negotiate that, because the other parent is having the same amount of time, typically, of a length of time to be away. So.
I wanted to talk briefly about remediation. All of these parenting plans, that I see have in fact, in Douglas County, Nebraska, there's a requirement before you come back for a contempt or a modification, you have to attempt mediation. I want to know what you see as some of the problems with the remediation clause, if you do see any problems with it.
Well, I mean, in every parenting plan, it states that parents have to go back to mediation to attempt it first to see if they can come to their own agreements before pursuing litigation. So remediation is, in as much as just the creation of a parenting plan is a big part of my practice, remediation might even be half of my practice, because people are coming back all of the time. Some of them are mad that they have to do it again, because they feel like they wouldn't be going back to court if they were able to fix it with their co-parent, because they have been trying and trying and trying and it's not working. And so they just want to get in front of a judge. They want to get in front of a decision maker. However, to your point earlier in the conversation, how many of these things that they are bringing, these conflicts that they are bringing, are going to be ones that infuriate is a melodramatic word, but that irritate judges. Many of them are ones that are minor. And again, we had this conversation in the first part of the podcast about they're not minor to the parents. They mean a lot to the parents, but in the grand scheme of what the court sees, it's something that they should be able to figure out themselves. So the value of coming back to remediation, depending upon what the issue is that they might say, I really tried hard with him to figure this out. I can't. This has become a problem. It's impacting the well-being of our child. What have you seen? What have other parents done that could help us in this situation? What are other agreements that have been made that we haven't considered that we could potentially give consideration to trialing and seeing if that solves the problem before pursuing litigation? So that's a conversation that we can have and try to create a customized approach or agreement to that. Sometimes it's that one parent absolutely is resolute to go to litigation and the other parent does not want to. Like they are like, I can't afford it, still trying to pay the first, experience off. And I need mediation because I need us to try to figure out a way through this because I can't pursue this other path with you. So I do think that there's real value in it of bringing people together to try to see one last ditch effort if they themselves have explored all of it, or with me can think through, oh, I never considered that before, or here's a possibility of something that we could do that's different. And sometimes we'll say, can we try this for 30 days? Can we try this for 60 days and see how it goes? And if you're still experiencing the same issues, then of course we're going to say there's no agreement in mediation. I'm going to draft a letter and then your attorneys can pursue litigation. It comes back a lot. There's a lot of issues that come back.
Yeah, I've made some judgments about remediation as a litigator that were probably wrong, and I make mistakes. I learn. One of the things that has happened to me in the last few years is I had a situation where a client was just being denied parenting time, and it was sort of a pattern for a long period of time. These new rules came out that said, you can't go to court for contempt. You have to try mediation first. And knowing the history, over many, many years, I thought to myself, well, that's going to cause a 4-6 month delay. The relationship between this parent and the child is going to be further and further distant. Why? That just feels like, what are you going to solve in mediation when one parent says this kid's not going to see you and fully is in contempt? How's mediation going to solve that? Well, that's the wrong attitude, right? But it's sometimes a litigator's attitude. Like, you want to champion the rights of your client who are being denied a fundamental sort of, kids are only young for so long. Right. And so I've come full circle a little bit on that, or come around to that. And one of the things that happened was I learned that the court passed these rules somewhat in a cooling off sort of way. I think courts are inundated with, sort of what we call modification actions, right? And I think courts are very comfortable with getting people divorced, doing original paternity cases. But then when these folks keep coming back and the file keeps getting thicker and thicker, they sort of feel like, well, I'm co-parenting with these people who are coming before me, and I don't want to co-parent. And why am I making decisions? And I remember the last time you were here, you talked about how a judge said, hey, do you love your kid? Do you love your kid? Well, you're letting the person who doesn't love your kid make all these decisions. And with modifications, judges are definitely feeling that way. And I think some of the rules that were passed on remediation in Douglas County were designed to lessen the burden and lessen the load on judges on modifications. I think they just hate them, and it doesn't mean that people don't have really, really legitimate reasons for bringing modification cases, but some of them are somewhat trivial. I mean, so again, another one of those maybe unsolvable things, but I do see that hurdle of remediation coming up as a frustration for parents and a respite for judges.
Well, that's a great way to frame it. What I find is that, parents will call me and they'll say, my attorney said that I need to call you to do mediation before we can move forward with this modification complaint. And when I hear them say it like that, I know that they're like, I can't believe I have to check this box. I can't believe I have to pay you money to do this. This is going to go nowhere. This is just delaying the inevitable. So then they'll come to me and I'll say, tell me what's going on. Tell me your story. And it's fascinating because a lot of times just in them sharing what they've been through or showing me messages and saying, this is why I can't do this. This is why I need sole legal custody. This is why my kid still doesn't have braces. This is. And many times, not all times, but many times they will break down and just say, I'm just so tired. I can't keep doing this. I don't know what to do anymore. Like, this is my only out. If I knew something different, I would be doing it. And so meeting them where they are, honoring how frustrating that it's been, because most of the times when parents go through divorce, I don't imagine that they're hoping to come back right away to do any of this. It's expensive, it's exhausting, and I think that they're hopeful that they can use the parenting plan and the decree and live for a little while and that it will work out. But by me listening, by me offering them possibilities of things that other people have done in the past, and then the consideration of trying to do that, then by me listening to the other party and maybe pulling out some more information and getting some ideas from that party. The other thing that I do promise, just ethically in the process, is that if this is going nowhere very quickly, I am not going to use your time or money inappropriately. So we will do what we have to do to satisfy the court and then make sure that you have the documentation that you need to move forward with your attorney. So I'm not going to drag out a process that isn't going anywhere.
Yeah. Well, I think, man, we've hit a number of topics again. I think it's been really helpful for me to hear what your experience has been. I think that anybody listening to part 1 and part 2 of the work that you and I have put together in this podcast would be much more informed going into mediation, and would have. I get a lot of folks that say, "Well, I'm going to mediation. You're not going to be there. What should I be asking about? What should I be thinking about?" And now I can just say, "Well, look at episode 1 and episode 2 of my podcast, and the Artful Divorce, and Shared Story, and and Kelly Gering is telling us, what we need to hear going into mediation." So I think we've covered a lot. There's probably other things that are, again, much more nuanced. I mean, we could talk about a number of different things that come up in mediation that we haven't had a chance to hit. But I think we've hit a lot of really good stuff.
Yes. And I guess as we close, I would just say, for anybody that's going through this process and anybody that's engaging mediation, I want to provide people with hope that you can be heard, that good questions will be asked, that they will be reality tested, that there are great opportunities and partnerships with attorneys and therapists and others within the community that have gone through this process themselves and have learned and can help, and that you're not alone in doing it. And that's why a podcast like this is so important, why co-parenting apps are so important, why resources for people, because the thing that they will always say to me is, I don't know what I don't know. I've never done this before. I'm scared. This is about my kids and about my financial stability, and it's nerve-wracking. And I will say, you're here, take a breath. We're going to work on it together. So my hope is that other people listening have hope for what can be on the other side.
Yeah, great. That's a great way to finish. Thank you so much.
Thank you.
All right. That's it. That's part 2. Thank you for listening and watching. Thanks for joining us on Artful Divorce. If today's episode was helpful, you can find more information at www.artfuldivorce.com. The information provided in this podcast is for general informational purposes only and is not intended to be legal advice. For personalized legal advice tailored to your situation, consult a qualified attorney licensed in your area.